Здравствуйте! Сегодня мы с вами продолжаем работу над текстом 7 статьи Европейской конвенции. Также мы узнаем, как некоторые пункты этой статьи толкуются Европейским судом по правам человека. Пока вы готовитесь к занятию, мы ознакомим вас с некоторыми фактами о работе ЕСПЧ. Европейский суд по правам человека состоит из судей, число которых равно числу государств, являющихся членами Совета Европы и ратифицировавших Европейскую конвенцию. В настоящее время их 47. Судьи ЕСПЧ независимы и не являются представителями государства. При рассмотрении жалоб суду помогает секретариат, который преимущественно состоит из юристов, граждан государств-членов Совета Европы. Их еще называют правовыми референтами. Они также полностью независимы от того государства, гражданами которого являются, и не представляют интересы ни заявителей, ни государств. European Court of Human Rights. Case Law. Unit 3. Фрагмент 4. Exercise 1. Read and translate the text. The concept of criminal offense.
Понятие уголовного правонарушения.
The criminal offense concept, infraction in the French version, has an autonomous meaning like criminal charge in Article 6 of the Convention.
Понятие уголовное правонарушение, infraction во французской версии, имеет автономное значение, как и уголовное обвинение в статье 6 Конвенции.
The three criteria set out in the case of Engel and others versus the Netherlands for assessing whether a charge is criminal within the meaning of Article 6 must also be applied to Article 7. Classification in domestic law. The very nature of the offense, the most important criterion, see Usila versus Finland, the degree of severity of the penalty that the person concerned risks incurring.
Для оценки того, является ли обвинение уголовным в смысле статьи 6, к статье 7 также должны применяться три критерия, изложенные в деле Энгель и другие против Нидерландов. Классификация в национальном праве, сам характер правонарушения, самый важный критерий, смотри дело Юсила против Финляндии. Степень строгости наказания, которому может подвергнуться обвиняемый.
In applying those criteria, the court held that a breach of military discipline did not fall within the criminal sphere for the purpose of either Article 6 or 7.
Применяя данные критерии, суд постановил, что нарушение воинской дисциплины не относится к уголовной сфере в смысле как статьи 6, так и статьи 7.
The same applies to dismissals and restrictions on employment of former KGB agents, a disciplinary offense committed by a student on university premises, and impeachment proceedings against the President of the Republic for gross violations of the Constitution.
Тоже относится к увольнениям и ограничениям на работу бывших агентов КГБ, дисциплинарному правонарушению, совершенному студентам в университетских помещениях, и процессу импичмента против президента республики за грубое нарушение Конституции.
In the absence of a criminal offense, the court found that the complaint was incompatible rationem materia with the provisions of the convention relied upon.
В отсутствие уголовного преступления суд установил, что жалоба была несовместимой рационе материи с учетом положений Конвенции.
Let's practice. Exercise 2. Listen to the dialogues. Can a breach of military discipline be regarded as criminal offense under Article 7?
No, it can't. A breach of military discipline did not fall within the criminal sphere for the purposes of either Article 6 or Article 7.
Does Article 7 encompass both criminal offenses and other acts, such as a disciplinary offense committed by a student on university premises and impeachment proceedings against the president.
No, it doesn't. The court held that a breach of military discipline did not fall within the criminal sphere for the purposes of either Article 6 or Article 7. The same applies to dismissals and restrictions on employment of former KGB agents, a disciplinary offense committed by a student on university premises, and impeachment proceedings against the President of the Republic for gross violations of the Constitution.
Сегодня у нас было последнее занятие по теме. В ходе занятия вы узнали, как Европейский суд по правам человека толкует положение статьи 7 Европейской конвенции, а о том, как исполняются решения суда и кто осуществляет контроль над их исполнением, вы узнаете из нашего видеосюжета. Приятного просмотра!
When the European Court of Human Rights delivers a judgment finding a violation of the European Convention on Human Rights, the state concerned, that's to say the respondent state in the proceedings before the court, is obliged to comply with that judgment as soon as it becomes final, to execute it.
In order to supervise the respondent state's compliance with this obligation, the final judgment is transmitted to the Committee of Ministers, which consists of representatives of all member states of the Council of Europe. This supervision by the committee is representative of the collective responsibility of all member states for due compliance with the court's judgments. What is expected of the respondent state?
A straightforward measure as regards the applicant is the payment by the state of the sum of money which the court awarded as just satisfaction. This sum is intended to cover moral or material damage suffered and costs and expenses incurred by the applicant.
However, the authorities of the respondent state are often called upon to take other measures in the interest of the applicant, so that the consequences of the violations suffered are erased as far as possible. This might include reopening unfair court proceedings, repealing the conviction of a journalist who has been wrongfully accused of defamation, or re-establishing contact between a parent and child who have been unjustly separated.
The authorities should also ensure that other people do not suffer similar violations. They should therefore adopt general measures to prevent that situation from arising in future. It may, for example, be necessary to amend the legislation in force or the practice of courts, or it may be necessary to improve conditions of detention.
The respondent state communicates the measures envisaged to the Committee of Ministers in the form of action plans. When the state considers that it has taken all the necessary measures, it sends the committee an action report. If, after examining it, the committee accepts the action report, the case is closed by the adoption of a final resolution.
During the supervision process, applicants can inform the committee of any problems that they encounter in obtaining the reparation due to them. What's more, civil society, as represented by NGOs and national institutions that promote and protect human rights, can also intervene and may communicate with the committee concerning the execution of a particular judgment.
The Committee of Ministers dedicates 4 meetings every year to performing its supervisory function. If necessary, it can also examine a case at one of its other meetings. If any problems are encountered with the execution of a judgment, the committee has a wide range of measures at its disposal to assist the state in overcoming those problems. What about friendly settlements and unilateral declarations?
The committee also ensures that friendly settlements are respected. It does not, however, supervise the implementation of unilateral declarations, for which responsibility lies with the court itself.
More information on execution and its supervision by the Committee of Ministers is available on the committee's website, and also that of the Department for the Execution of the Judgments of the European Court of Human Rights, which assists the committee in carrying out its supervisory role.